Welcome to a program of the Dallas Bar Association's Public Forum Committee. Today's topic is executive orders in the federal government. Your panelists are Steve Vladeck, professor of law at Georgetown Law Center, and Chad Baruch, managing shareholder of the Johnston, Tobey, Baruch law firm. Moderating today's discussion is Loren Jacobson, associate professor of law at UNT Dallas College of Law. Many thanks to Steve, Chad, and Loren for participating today. And of course, thanks as always to the Bar Association for the team there for today's arrangements. The participants will take a few questions near the program's conclusion. Please type your questions in the Q&A function of the Zoom. Texas CLE credit is available for members of the Dallas Bar Association. On the honor system, the CLE course number will be in the chat or in the Q&A or both at the program's conclusion. And with that, Loren, over to you, please. Thank you.
Thank you so much, Russ. I really appreciate it. We're looking forward to speaking to you all about executive orders today. So we'll get started. Steve, can you tell us what is an executive order?
We'll starting with an easy question. So, let me just say thanks, of course, Loren, to you for moderating this and to Russ for setting this up. I guess, what is an executive order? An executive order is a formal memorandum signed by the president and published. It has to be published in the Federal Register. And it is basically a command, right, that the president issues to other entities or personnel within the executive branch based upon the president's assertion of power that he derives either from the Constitution or from a statute. And so, executive orders are not themselves law, but they are the president's interpretations of law issued in a way where they are meant to constrain at least those who are directly answerable to the president. And so many of them are not especially controversial. When the president restructures an agency, for example, that's usually by executive order when the president just sort of does the steps any president would take to carry a new statute into effect. But Loren, I think part of why we're here is because executive orders have become more and more controversial as they have veered further and further from their statutory and constitutional underpinnings. And so I will stop there so I don't step on Chad's toes.
All right, so you told us that when the president issues an executive order, he relies either on constitutional or statutory authority. Is there a provision in the Constitution that explicitly gives the president the ability to issue executive orders?
No, although I will say I don't think that that's fatal. So Article 2 does give the president the power to take care that the laws be faithfully executed. And, if we just sort of blue sky this for a second, laws are often ambiguous. And even laws that are not ambiguous often give the executive branch discretion. And so even in the most neutral, Aaron Sorkin-esque idealized vision of how the government is supposed to work, presidents will need, Loren, to resolve ambiguities in statutes. Presidents will need to explain what they will and won't enforce in a statute that expressly gives the executive branch discretion. And so the Constitution does not expressly contemplate executive orders. I do think the Constitution expressly contemplates executive discretion. And insofar as executive orders are a manifestation of that discretion, I think they're fine. Indeed, if not, they're helpful because they are public documents that people like us can go read and say, oh, this is how the executive branch is interpreting the latest statute. It really is one of those things where it's not the basic idea that's the problem, right? It's the increasing and increasingly controversial applications thereof.
All right, great. So we will get to those. You already kind of mentioned this.
Can I interject?
Yeah, absolutely, Chad.
I wanted to mention, sort of building on what Steve said, that, I think there's a perception out there that every time the president signs an executive order, there's some sort of a zero-sum game being played with the legislative branch. And that's certainly not true. Quite often, this is being done at the legislative branches at Congress's behest. FDR would be the best example of that in history. Congress was pushing authority onto him like crazy during World War II. So this idea that the president is always taking authority from the legislative branches in the overwhelming majority of executive orders is not the situation necessarily.
Right. And in fact, Congress is and meant to be this beast that moves slowly and deliberates, and we need an executive branch, right? The whole job of the president is to execute the law. That's why they're the executive branch, and we need an executive who can execute the law. And as both of you have said, Congress often delegates the authority to the more nimble branch to execute the law and gives some discretion, right, to the president to decide how to execute the law. All right, so let's kind of go back to this a little bit. I think you touched on this already, Steve, but so executive orders aren't laws, is that right?
They're not laws in any meaningful sense. They are directives that the president issues that bind only, right, individuals who serve under the president and are subject to his direct political control. And they bind those folks, Loren, not of their own. They bind them because not following an executive order would presumably be grounds for those folks to be fired, right? So they're not formally binding on anyone. They are practically binding on the executive branch.
Great, perfect. And so, yeah, right, they will set out the policy and the priorities of the president. So let's talk about a little bit. I mean, we're here because executive orders are in the news quite a bit. But let's maybe talk a little bit about, traditionally, how can presidents use executive orders? How have they used executive orders? What kinds of things have they done? And we're not going to cover everything because there are thousands and thousands and thousands of executive orders that have been issued over time. But to give folks who have joined us an idea of the types of things that presidents do and have done with executive orders.
Sure, I can jump in a little bit on that. It's all right. They date back to the dawn of the Republic. George Washington used executive orders, and interestingly enough, their sort of their benign nature and their controversial nature also dates back to the Washington presidency. President Washington, used an executive order. It was called a proclamation, but he declared neutrality in a conflict between England and Britain, and that was somewhat controversial. James Madison, in particular, objected to that, thought it exceeded the scope of his authority. The controversy ended up being quelled rather quickly when Congress sort of legislatively endorsed what he had done. But that's an example. He used another proclamation in connection with the Whiskey Rebellion. So these things aren't by any stretch new. Certainly Abraham Lincoln used executive orders, although he didn't sign that many. I think he signed less than 50 in his presidency, but he used them pretty aggressively. He wasn't big on numbers, but he was big in scope at times. Particularly during the early months of the Civil War, he was managing a lot of our military mobilization through executive orders. Certainly another controversial example would be President Johnston, after the Civil War, issuing an executive order, his famous Christmas proclamation pardoning Confederates. The peak usage, and this may surprise people, we do not live in the era of peak usage of executive orders. That came in the middle part of the 20th century. And probably not by coincidence that the two most frequent users were the two wartime presidents. Franklin Delano Roosevelt signed far more executive orders than any other president, even when you take into account his length of term. Woodrow Wilson would be number two. And to sort of give you an idea of the numbers, FDR signed almost 4,000 executive orders. Ronald Reagan signed 381. So that, and he's sort of typical of a modern president. I will say that President Trump, there's a big difference between Trump 1 and Trump 2 in terms of executive orders, particularly in terms of numbers, but also probably in terms of sort of the scope. He is on pace to be one of the, if you calculate it by year, number per year, Trump 1 was very consistent with modern presidents, Obama, Biden, Bush. Trump 2 is not. Trump 2 is going to end up being one of the most frequent users of executive orders if he continues at this pace. So,
great. Steve, do you have anything else to add in terms of the way presidents use executive orders?
Just that, I mean, I think there are two sides. I mean, as Chad notes, there are two sides to this equation, and it's worth playing out Congress's role and how the shifting of Congress's role has, I think, increased the aperture of executive orders. So just, the Harry Truman famously called, I think it was either the 89th or the 90th Congress, the do nothing Congress, because it passed so few statutes. And that Congress, I think, passed 906 statutes. I haven't looked at how many we've gotten out of this one, but my bet is it's still in the relatively modest 2 digits, right? That creates structural consequences, whether the president's a Democrat or a Republican, because presidents of both parties are left with fewer updated statutes to carry into effect their policy agenda. And so that puts much more pressure on presidents of both parties to sort of go into this more controversial area of executive orders, to try to actually sort of change the meaning of legislation or stretch the meaning of legislation because they can't get statutes through Congress. And so, FDR is a fascinating counterexample, right? Because for all the executive orders he signed, much of the controversy around FDR rested on about 12 or 13 statutes that FDR got Congress to enact as part of the New Deal, right? Like the statutes were controversial, but they were statutes, right? President Trump hasn't gotten Congress to enact virtually anything, and not as relevant to almost all the litigation that folks are, familiar with. And so, it's not just that there's like these different categories, Loren. It's that I think as Congress has done less to substantively legislate, that has put enormous pressure on presidents, regardless of their politics, to resort to executive orders and other mechanisms to try to carry their agenda into effect. Part of the mess we're in today is not a Democratic or Republican partisan point. It's an institutional point about how presidents of both parties are left to ever more controversial authorities to do whatever they think is most urgent for the American people.
Yeah, and I think that's an important point because I think, we are in a time and, clearly there have been a number of controversial orders, executive orders put in place by this president. But, we saw similar complaints, right? When President Clinton did not have a Congress willing to help him, he issued many, many, many executive orders to try to deal with issues where Congress was not going to enact statutes to help him. I think that was true for President Obama as well, although I think President Clinton's were maybe more controversial. But yeah, I think in some ways the kind of boundary pushing nature of the executive orders we've seen more in the modern era are because of this breakdown, where the president can't get Congress necessarily to work with him.
My favorite quote about executive orders kind of goes to the point that both of you are making. It's from one of the Clinton officials who said one time, "Stroke of the pen, law of the land, pretty cool." And I think that sort of sums up the use that both of you are describing.
Yeah. All right. So we've talked about, the president will often, when the president issues executive order, he needs to rely either on some constitutional authority or statutory authority. So let's talk about how the Supreme Court evaluates whether an executive order is constitutional. What framework does the Supreme Court generally use to evaluate whether an executive order is constitutional?
So this is where things get a little tricky because the Supreme Court isn't necessarily consistent about how it treats executive orders. I guess I would boil it down to the court usually starts from the proposition that what it's reviewing is not the executive order, right, but the underlying legal claim. And the question is, does the president have the authority he claims? And so that brings us into the more conventional land of statutory and constitutional interpretation. And so just to take one recent example, the birthright citizenship case from last month is probably, fresh on folks' minds. There the court took the question presented as whether President Trump's executive order from last January to limit the scope of birthright citizenship was lawful, meaning was it consistent with the citizenship clause of the 14th Amendment, and was it consistent with the relevant statutes Congress had enacted in 1940 and 1952 to carry into power? And so, I don't know that the court had a particular test or like a standard of scrutiny, which we're so used to seeing in other contexts. Rather, it was sort of an administrative law case, right? Where the question was, is the executive branch's interpretation one that we find to be correct? And the court said no. I think the trickier part, Loren, is that there are lots of examples, and Chad knows this from all the history of the court showing different degrees of deference to the executive branch when it comes to either factual or legal interpretations relating to executive orders. But even that, as we know, has shifted quite a bit in recent years. So I would say there's no one like magic black letter, put it in your outline test for when an executive order is lawful, but it's the same question. Does the federal government have the statutory or constitutional power to do the thing the president says it can do?
So I have a question rather than a comment. Since I'm here with two law professors, it seems, I agree with everything you said. And my question is, do you think that represents sort of a fundamental shift in the court's framework? Because, you both teach Youngstown Steel every year, right? And that was a very sort of different approach, I think, in terms of Justice Jackson's analysis of from where the source to issue the order derives, and sort of talking about the different categories and how the president's power ebbs and flows. Do you believe this represents a little bit different way of the court evaluating executive orders?
I mean, I'm happy to let Loren weigh in too. I mean, I'll just say yes, but I think it goes beyond executive orders. I mean, I think I went to law school in the era of what the lawyers would call the Caroline Products footnote 4 approach to constitutional law, right? Which was a fairly deferential but not abdicating standard of review for especially the federal government, right? Where, if the president's interpretation of the statute was reasonable, he usually won. Chad, I think that's changed, and I think it's changed in multiple directions and across multiple axes. This is a Supreme Court that we have today, for better or for worse, that doesn't like deference very much, right? Maybe outside of the national security context. And so this is a court that never liked the Caroline Products framework. This is a court that is very, very willing to sort of substitute its own judgment for that of Congress. And so I think the reality is that part of why the court ends up looking so political these days, whether or not we think it is because the way the review goes in the Supreme Court right now, Chad, there's so much room for the justices to basically sort of do their own thing, right? And let their own views decide what they think of the president's actions.
So I think I saw something in the chat. Professor Vladeck mentioned it's footnote 4 of a case called Caroline Products. It's the most famous footnote in constitutional law history. I guess I'll answer the question by kind of taking a step back. I think, and I'm going to talk about Youngstown Steel, which is called the steel seizure cases. I still think there are two frameworks in that case that the court is applying, but the way the court's applying it, I agree, it is using kind of methods of statutory interpretation that provide less deference. So just to take a step back and explain, Youngstown involves an executive order. It was an executive order issued during the Korean War by Truman, giving authority to the Secretary of Commerce to seize the steel mills. And the Secretary of Commerce did that. He seized the steel mills in order to prevent a strike, basically. And the question was whether this executive order was constitutional. And Truman asserted that he had power as part of his commander-in-chief authority, and also as part of, his, duty to fully and faithfully execute the law to issue the executive order. And we have a majority opinion by Justice Black that no one follows. And then we have concurrences, a concurrence by Justice Jackson, where he sets out a framework where he says, look, they're kind of like these 3 zones, and depending on where the president is acting, right? We're going to evaluate those zones differently. So in the first zone, the president acts with explicit statutory or constitutional authority. And in that zone, the president is at his apex of power, right? And this is where we can get into, right? So then that requires the court to look at this, if it's statutory authority he's relying on, to look at the statute, interpret the statute. And that's where I think we kind of get into the major questions doctrine and this lack of deference. But that's in, zone one. And then in zone two, Jackson says this is where Congress hasn't spoken. We don't have explicit authority from the Constitution. And he calls it the zone of twilight, where the president, where the president may have authority to act. He kind of leaves it there. And then he has zone three, where the president is acting contrary to Congress. Congress has either through statute or otherwise expressly or impliedly made its will clear. The president acts contrary to that. And he says in that zone, zone three, the president is in his lowest ebb of power unless he can rely on his preclusive, exclusive, conclusive authority, meaning he can rely on a specific provision in the Constitution that gives him and him alone the authority to act the way he does. And I do think the court still uses that framework. There's also another concurrence by Justice Douglas that basically says, look, the president can do what he wants unless he is violating another provision of the Constitution or usurping the authority of another branch. And I think the court uses those frameworks, but maybe the way the court is applying the framework, and we can get to this, is with less deference than we've seen. Although in Youngstown, the court found that Truman did not have authority to issue the executive order. That the powers that he was relying on really weren't powers that he could, like the commander-in-chief authority wasn't enough, even though the Korean War was going on, that this was too attenuated from the Korean War. And that anyway, that the powers he's relying on were shared powers. So I think the framework is kind of still there, but I agree with Steve that the way the court is applying the framework has changed. All right, so let's talk about when is the court more likely to find an executive order constitutional?
Well, I mean, so an executive order that does not stray from the text of the relevant statute or constitutional provision, and or that is sort of reflecting a long and well-established interpretation of that, those tend not to even be challenged, right? I mean, like, you don't see litigation about every executive order. So, not every executive order is vulnerable to judicial challenge, nor should it be. I think the judicial challenge tends to come when there are colorable arguments that the executive order has strayed, that it has strayed from what Congress authorized, and that there's no fallback, inherent constitutional argument for what the president's doing. And then, it's off to the races, because then we see litigants. And I think, part of why there's so much more litigation over executive orders these days is not just there are more executive orders, but like it is easier today to basically find a super friendly place to bring your lawsuit, right? Because of the sort of ideological polarization of the federal judiciary, there are now entire district court benches that might be viewed as more likely to be skeptical of an executive order from this president versus that president. And so I think it's not that like there's this sort of magic litmus test for the executive orders that are and are not lawful. It's that there's like a point past which an executive order becomes vulnerable to even any legal challenge. And then we're off to the races, because if there's any legal challenge, chances are it's going to end up in the court in the country most likely to find that challenge plausible.
I think it's probably worth mentioning another aspect of the analysis that's rarer but does sometimes figure in, which is how Congress responds to an executive order. There are some cases out there discussing the idea of Congress acquiescing in or ratifying an executive order. So I think that's somewhat more rare, but some of the cases that figures into the court's analysis. One of the things I wanted to mention that I find interesting, which is now plainly, we've seen it in at least 2 different cases. One of the things the court, we've talked about what they do look at. One of the things they're not going to look at, apparently, is what the president says publicly about an executive order. That happened during Trump 1, and it was like, okay, is this just a one-time thing? But now we've seen it during Trump 2 as well. My favorite example of it is actually the first case back in 2018, the immigration case, Trump versus Hawaii, where Justice Kennedy writes a concurrence to basically say, and to back up for those of you who don't remember, that was a case involving some executive orders that purportedly, well, they did target people from certain countries. Certain people were barred from entering the country from different countries. And the allegation was that they were targeting based on religion. And there were a lot of public comments the president made that seemed to support that approach. And Justice Kennedy wrote a concurrence that was basically an open letter to the president that said, "Dear Mr. President, this should have been a lot easier for us than it was. If you would just be a little more careful in the future about what you say about these orders, we would be so appreciative. Sincerely yours, Justice Kennedy." That plainly had no effect. Now, this term again, we've seen a similar, discussion between the majority and the dissenters about whether you can take those things into account. So I found that a little bit interesting. We're going to evaluate it on the basis of the order, not on what the president says about the order.
I think that's true, and I also think that the Trump versus Hawaii and a little bit the more recent case, but also goes to kind of one area where I do think the court is willing to give the president more deference with respect to executive orders, and that's in national security and foreign affairs, right? And I think that the majority in Hawaii versus Trump, it's an immigration case, but they saw it as being related to foreign affairs, and therefore gave the president a lot of deference and ignored his public statements in order to apply the test that would give him the most deference. And this goes back all the way to a case called Curtis Wright during a period where in 1936 where the court did not looked carefully at congressional delegations to the president and domestically did not, well, at least 2 times did not allow it when the president acted with respect to foreign affairs, gave the president much more deference and much more room to do that. So I do think in that area, the court is, when the president is using an executive order to deal with foreign affairs, the court is more likely, if it characterizes what he's doing that way, because sometimes they won't, to give him deference.
Well, I'll just say, I think there are 2 different points there, Loren, and I think it's worth pulling them apart, right? The first is, in the foreign affairs space, presidents have presumably at least a bit more of a claim to unilateral Article 2 power, if not to exclusive and preclusive Article 2 power, where now the court is not just deciding whether the statute or constitution says the president can do this, but actually now they're going into power that the court has always been in charge of sort of explicating. So at least on that front, I think that's always been true with the slipperiness of what counts as foreign affairs and what doesn't. The other point is, I think it's worth flagging. I mean, Trump versus Hawaii and the TPS cases from this term, Mullen versus Doe, there's a lot of evidence out there that the court is being wildly inconsistent about when it cares about the president's public comments or a government bureaucrat's comments and when it doesn't. I mean, just to take one, folks might have seen the headlines earlier this term when Chief Justice Roberts, the New York Times published all these internal memos about the Supreme Court's granting of a stay in the Clean Power Plan cases in 2016. And Chief Justice Roberts' internal memos had relied heavily on the statements of a deputy administrator of the EPA for look at what the EPA is really trying to do. And it's so the deputy administrator of the EPA, we care what they say, but we don't really care what the president says. Loren, I think descriptively you're absolutely right. I think that's a problem because it seems like, especially if you're going to embrace what the court calls the unitary executive theory of presidential power, the only person whose comment should matter are the presidents. And yet the court has this alarming tendency to sort of whitewash them, especially in Trump cases.
Mm-hmm. Yeah. All right. So then we've kind of danced around this a little bit. We've mentioned, well, we haven't actually mentioned the tariff case, but as we've been talking about, one issue that continually arises in these cases, considering whether executive orders are valid, constitutional, is whether they're authorized by the statute, right? And so can you, either of you, both of you, explain how and when the court will use statutory interpretation to evaluate whether an executive order is constitutional? And we have these principles that the court has used, in addition to statutory interpretation, like the horribly named non-delegation delegation doctrine, and more recently, the major question doctrine. So can you talk a little bit about how the court does statutory interpretation, the non-delegation doctrine, major question doctrine, and anything else you think is relevant to folks understanding how the court goes about deciding?
So again, this assumes the court is consistent when it isn't always. So I guess what I'll say is today's Supreme Court cares deeply about this thing called the major questions doctrine. So we should start with it, right? And so a statute could do one of two things, right? It could either specifically and expressly authorize the president to take particular actions, in which case we tend not to spend much time fighting about it, or it could do so implicitly because it uses ambiguous language. And the question is, Loren, what to do with ambiguity? So, not that long ago, the court had a series of complicated overlapping rules for what to do with ambiguity, where the idea was, we'll use different principles to try to figure out what Congress must have meant when they use this word that doesn't have a plain meaning. The court has become more and more allergic to that. And so the major questions doctrine is sort of one manifestation of the allergy, where under the major questions doctrine, if the underlying government action involves a question of, quote, vast political or economic significance, and let's pause there for a moment to note how subjective those words are, vast and significance, right? But if the program has vast economic political significance, then ambiguity is fatal, meaning, right, the president has no power to do the thing, even if the reading might be reasonable. And a couple of really important recent examples of this, the court's decision this February blocking President Trump's tariffs. The majority opinion by Chief Justice Roberts relied heavily on the major questions doctrine, although the 3 Democratic appointees didn't endorse that part of it. And the court's ruling blocking President Biden's student loan debt forgiveness program also relied heavily on the major questions doctrine. And so at least in those spaces, what we're seeing is it's actually harder for presidents to use executive orders to try to resolve ambiguities in favor of a particular policy, because the bigger the policy, the less wiggle room the ambiguity gives them. That doesn't cover every case. I mean, President Trump won a series of immigration cases this term about the interpretation of various immigration laws, but that is part of why we're seeing so much more of this litigation.
Yeah, and I think with respect to the major questions doctrine, so I think you've said a couple of things, maybe we can tease them out. On the one hand, it essentially, as you said, means the court is not going to be deferential to the president's interpretation of a statute or the executive branch's interpretation of a statute. And I don't really want to use this language, but I love will carefully scrutinize the statute and requires the statute to be clear, right? Not ambiguous. But then we also have, maybe the subjectivity of the major questions doctrine, which I think you've also alluded to or actually made quite clear. And that is the court decides whether, right, the statute or whether the president is claiming broad authority in an issue of, economic and political significance. And that can be very subjective. I don't know if I don't need to talk about if you want to talk about, in the tariffs case, right? Some of our, Alito Thomas dissenters were kind of making this argument that there is a major question exception to the major questions doctrine, which is we don't apply it, in foreign affairs. And I think Roberts in the majority writes, well, no, there's no major questions exception to the major questions doctrine. And it shows, in some ways, the subjectivity of the application, which is why I think that our Democratic appointees, our dissenters, they object to it because it is so subjective. And I think their view is let's just do straight statutory interpretation.
I was going to talk about this a little more in the context. I know we're going to talk
Sure.
about this case specifically, so I'll kind of reserve my comments on it for that. The only other thing I would add is also this debates over this doctrine are all over the tariffs decision. But there's even a debate as to whether it's, depending on who you listen to, this is a long-standing and entrenched doctrine, or it's brand spanking new, and we just invented it to get rid of Biden's programs, right? I mean, there's disagreement at every level about this doctrine. Very, very interesting. And I'm curious to know where you all fall. I'd be interested to hear your thoughts on that question. How new is this doctrine? How entrenched is it in the court's analysis? I mean, I know I have an answer, but I'm very curious to hear yours.
So, I mean, I'll say, I think you can find, Chad, elements of the major questions doctrine in rulings going back to like the 1990s and 2000s. The famous quote, Congress doesn't hide elephants in foxholes or mouse holes, I'm sorry, right? Which is I think it's from a 2001 decision. But there's a difference between using this idea as a means of interpreting ambiguous language and the categorical on-off switch that the majority said it reflects only in 2022. Right. And so this is part of why the academics end up yelling at each other, is because they're both sides are right, that like the court didn't treat this as a categorical limit on the executive branch's interpretive authority until 2022. But you could find earlier cases where that's clearly doing work. And I'll just say, like, normatively, I mean, my own view is we ought to distinguish between when Congress wrote the statute, right? So holding Congress to the major questions doctrine for statutes it wrote at a time when the doctrine in any form didn't exist seems very unfair to Congress versus going forward, right? Versus saying, well, Congress now knows that the Supreme Court is demanding this degree of specificity. And so new statutes, right? This, I think, is sort of a problem with the court's approach, which is it is retroactively holding Congress to a higher standard. Chad, even if there's debate about exactly when the retroactive line starts.
I can't tell you how pleased I am to hear that answer. I gave the Supreme Court update in Galveston last week, and I said essentially that, and I'm shocked to discover I might have been right. So thank you for that.
Or we're wrong together, which, I'm happy to be in that boat with you.
I'm comfortable with that too.
I would say that I think that the major questions doctrine, so we didn't talk about the non-delegation doctrine, but there are two cases in 1936. Well, let me take a step back. In a statute, right, it's Congress that legislates, president has executive authority, but the court has always said that Congress can delegate authority to the president. That's what we're talking about today. But it has said that in order to ensure that he is not legislating or setting policy, that there are, sufficient guidelines, what the court calls intelligible principles, to circumscribe the president's decision making. And in only two cases in 1936, the court found that a statute did not have sufficient intelligible principles. And so the president couldn't act in that area. And that's called the non-delegation doctrine. Since 1936, the court has found almost any language anywhere to be intelligible principles, or has, and like, for example, a case called Gundy in 2019, has interpreted the statute in a way to give the president or the executive, in that case, it was the attorney general, sufficient intelligible principles to, cabin the decision-making power. I think that there was some thought. So what has happened with the court, right? We have Gorsuch and other conservative justices who are not lovers of the administrative state. And so particularly once Gorsuch came on the court, he wrote I think it was a dissent in this case called Gundy. I think people for a while were talking about, well, there'll be a revival of this non-delegation doctrine to cabin the president's power. And I think instead the major questions doctrine has taken care of that. It has almost taken the place of the non-delegation doctrine and done the work of what the non-delegation doctrine was, a revival of the non-delegation doctrine would have done. I don't know.
So, I mean, I think, Loren, practically that's right? That as a description of what the Supreme Court has been doing, the sort of deflation of the Gorsuch push to revive the non-delegation doctrine is entirely caught up in the rise of the major questions doctrine. I want to sort of register a dissent that that's completely incoherent. And it's not what you said, right? But that the court's behavior is incoherent because the non-delegation doctrine, love it or hate it, is the idea that Congress can't give the president these powers, which is obviously a constitutional argument, right? The major questions doctrine is just the sort of junior varsity, Congress can, but it has to use super special magic words. Which again, when you're applying it to an old Congress, right, I think is doubly unfair. But also, I think the court itself doesn't apply it consistently. And you mentioned the dissent in the tariffs case. I know I'm jumping ahead a bit, but the Kavanaugh dissent in suggesting that there's a foreign relations and national security exception in the major questions doctrine never engages with the majority opinion in the student loan case from the Biden administration, where the underlying statute was a national emergency statute and where the program was based on the COVID emergency. And so, the problem, to me, the problem is that what all of this does, the non-delegation doctrine would have been a cleaner, much more formal limit that would have more easily applied to presidents of both parties. By turning it into this more subjective, malleable test, the court opens itself up, right, to treating different presidents differently based on how much they do or don't buy what the government's doing. And I think that's part of where you get the charges and the appearance of political behavior, because the court's own doctrines lead the justices to be able to say, oh, well, these two seemingly similar cases come out differently. Oh, and what a coincidence. One had a Republican president, one had a Democrat.
I want to mention something because I know you guys as constitutional law professors, things like the major questions doctrine and the non-delegation doctrine, they're so at the heart of what you do on a day-to-day basis. You'll be surprised to find out that most practicing lawyers don't deal with these doctrines very often. So for the folks watching, the boots on the ground people, I will say was fascinating. The non-delegation doctrine had such what I would call downstream effects during COVID. The local litigation we were involved in over COVID response measures, all of that briefing, right in Dallas, Texas, and Houston and Austin, discussing what Clay Jenkins was doing, what Governor Abbott was doing. It was all about the non-delegation doctrine. So it definitely landed far downstream during the COVID crisis. And I'm not so sure a lot of the lower court and local decisions weren't affected by the politics of COVID.
On the one hand, I want to say I'm sorry. On the other hand, as the nerdy con law professor, oh, what could be better that the non-delegation doctrine becomes vivid and real? Most of my students are like, ugh. All right, so we've mentioned the tariffs case, the birthright citizenship case. Are there other recent cases or recent decisions that you guys would like to talk about in terms of, or want to talk more about the cases we've already talked about? In order to, where the court's considered an executive order.
I'm sorry, Chad, go ahead.
Yeah, no, you go ahead. I'm going to talk a little bit about tariffs, but you go ahead. I'll wait for you.
Good. So I wasn't. I would just say I think we should be a little careful about only counting cases where the court is formally interpreting executive orders, because there's a lot of cases where the executive branch is acting based upon interpretations of statutes that have the de facto force of executive orders. So almost every immigration case that reaches the Supreme Court these days, right, involves the executive branch interpreting a statute usually differently from its predecessors. And it's the same bucket of questions. So I would say, the court had a number of these cases this term, and actually, despite the two biggest headline cases, which were birthright citizenship and tariffs, the government actually won more of those cases than it lost, right? And the executive branch prevailed on more of its interpretations than it didn't. And one of the tricky things that we always run into when trying to cover the Supreme Court is there's a denominator, not just a numerator, right? And so, I know Chad's going to talk about tariffs, and he's right to. I just want to say, don't come away from this conversation with the idea that the court is reining in presidential power, right? Actually, to me, the tariffs and birthright are the only two examples really from this whole term of Trump losing on these kinds of cases, where he won on a whole bunch of other ones.
Let me ask a follow-up question then, if I may. And this is a sincere question. It's not like one of those where we've arranged it in advance. I don't know the answer, and I'm curious to hear it. Certainly that, yes, the administration is winning a lot more than it's losing. Is that due in part, is the administration being wise in its selection of what it brings to the U.S. Supreme Court? Is that partially accounting for that one loss?
Oh, absolutely. There's no question, Chad. And I would say it's being savvy in two different respects. The first is it's being savvy about which cases it's bringing up, and the second is when. The birthright citizenship case did not come back on an emergency application, right? The law firm cases have not come up on emergency applications, right? They're being very savvy. The only reason why the birthright citizenship case came back at all is because during the oral argument in the first go-round last year, the court basically made Solicitor General Sauer promise to bring it back. So yes, this is part of the problem in general of just reading the top lines of end of Supreme Court term media accounts, which is don't lose sight of the fact that, one, the cases involving the Trump administration are invariably the ones it chose to bring to the court. And two, these are all cases the justices chose to hear. There's a lot of selection bias in that data.
No, I only raised the point because I think it's important for people to remember that there are all sorts of executive orders out there being handled at the lower court level that are still, and I don't want to take a side here, but for better or worse, they're having enormous impacts. And locally, we certainly saw it with the Sussman firm, the effect it had on that law firm that aren't getting to the Supreme Court necessarily, but still are out there in the real world affecting real people.
Yeah, and I think that's true, not just as Steve said, not just of executive orders, but a lot of executive conduct. The 𝐏𝐥𝐸 order with respect to transgender members of the military. There's a lot of executive conduct that's actually, the president's authorizing it, but it's the agency that's taking action, and that's all still percolating below. All right, so I don't know, Chad, do you want to talk a little bit more about tariffs?
Sure. I know everybody's up in arms about the, cases concerning the president's ability to hire and fire people in the executive branch and all that, but it's just hard for me to believe that any of these cases has a greater impact or will have a greater impact than the tariffs decision. My goodness. And it's so interesting to me, this sort of 3-3-3 breakdown in the decision. I've presented on it 5 or 6 times now, and I still use a little scorecard because I think it's so helpful to people who aren't familiar with the decision. And it really is a sort of what you could call a 3-3-3 split with all sorts of other grievances being worked out under the surface, if you will. As Steve said, the majority, you've got the Roberts, Barrett, and Gorsuch who say we're going to invalidate this on 2 separate grounds. Number one, we can just sort of look at what I guess we can just call sort of traditional statutory analysis. I think this is important. They do more than some of the other decisions. Maybe the tariffs decision harkens back to the steel seizure cases a little bit, because in the majority opinion, it goes out of its way to make clear the limited basis the president is claiming for this power, which is purely statutory. So it kind of goes back to that three-tiered analysis Justice Jackson uses. But the majority says statute doesn't say that, plain and simple, but also under the major questions doctrine, this would fail as well. And the liberals join only as to the first part. They say, yeah, we're not getting into major questions, but we can just look at the statute and agree that it doesn't give this authority. Fine. That's the Kagan concurrence. Jackson writes a separate concurrence to talk about legislative history. Basically, what she says is, look, I want to just talk about the fact that we ought to be more liberal in our use of looking at legislative intent. And she says there are, not always, but there are times when Congress tells us specifically what it intends, and rather than trying to divine that intent from the language of the statute, why don't we just look at what Congress told us? So she writes separately on that. Gorsuch writes, I mean, this is the best opinion by far, right? Like, I've heard so many unbelievably hilarious descriptions of this type. The best is whoever called it the Festivus of grievances, right?
No, today the Corleone family settles all business.
Yeah, there you go. Yeah, yes. You could certainly call it a pox on both their houses. I mean, anything. But Gorsuch's point, and I think this is to Steve's point as well, is he says, look, all of you are just being so wildly inconsistent in your evaluation of how all this works. If it's Biden, we go one way. If it's Trump, we go the other way. And he points this arrow at both sides equally. He goes after the liberals. He goes after the conservatives. He says we should have one rule. And in Gorsuch's opinion, that one rule should be a robust and substantive major questions doctrine. He says this is its own substantive doctrine. It's not just part of the interpretive process. And that's really what he's writing about, is to shore up the major questions doctrine. As both of the professors said, Kavanaugh and Thomas dissent, and they raise this issue of an exception to the doctrine for foreign policy and other related issues. And then my second favorite opinion has to be Barrett's. And I even want to read a couple of lines out. So Barrett is engaging with Gorsuch over the nature of the major questions doctrine. She's saying, look, it's not a separate doctrine. It's just part of our textualist analysis. And she particularly objects to the idea that it could be a separate doctrine. She says, if we're going to put our thumb on the interpretive scale, then being a textualist, now I have a real problem with that. I'm looking at the text, and this is just a lens through which I can endorse textualism. And she says in here, where is it here? There's just a wonderful, oh goodness, now I've lost it. But she talks about Gorsuch being so intent on making her a convert that she regrets to inform him she isn't one, or something. But in any event, I don't know about y'all. I thought this was the most fascinating. I'm like, oh, wouldn't you love to have heard the discussions behind closed doors?
Absolutely. Yeah, and I agree that, yeah, Gorsuch is it's just a takedown of everybody. You wonder how these guys get along. All right, so we have a few more minutes left, and I'm going to see if we have any questions in the Q&A. All right, so our first question, but this is from one of my former students. Do you think that Congress should pull back some of the authority it has delegated to the executive in the future? And if so, what does that look like?
So this is what's known as a softball question in the biz, because the answer is absolutely. But it's worth flagging on a couple of ways in which the Supreme Court has made it harder. So, we used to have in a series of statutes these provisions where either chamber of Congress could basically reject, right, particular presidential applications of statutes. Immigration law is a good example of this. It's known as the legislative veto. And the Supreme Court in a 1983 decision called INS versus Chadha, CHADHA, said those were unconstitutional, taking a tool away from Congress. The court just took another tool away from Congress in Trump versus Slaughter by basically getting rid of independent agencies and the idea that Congress can insulate at least some executive branch activity from direct presidential control. And so what that really means is now, to the question, Loren, Congress has two choices. or I guess three choices, right? One is to just not delegate the authority in the first place. One is to sunset the authority, right? Which is, something Congress has done in some areas, but not others, where basically put the affirmative onus on Congress to reauthorize something as opposed to having a statute sit out there forever. A good example of this, take the authorization for the use of military force that Congress passed 1 week after 9/11. That statute's still on the books. And, it is still used by presidents of both parties, even though it's been 25 years and al-Qaeda isn't really, a thing anymore. So, why didn't that statute have a sunset? The third piece, though, is the appropriation side, right? Congress's power of the purse. And I think what we're going to see in Congress's going forward is much more aggressive use of the power of the purse as a way of trying to enforce substantive constraints. Because, if Congress can't insulate the officers, and if Congress can't insulate the policies, and if Congress isn't going to sunset, really all it can do then is use funding. Like, we'll fund this, but not that. We'll give you money for this, but not that. And I think that's where a lot of focus is going to be going forward.
I think it's worth noting, too, that maybe people forget, Congress derives benefits from things like deference, right? I mean, it allows Congress to evade a lot of responsibility by delegating to the executive, allowing the executive to interpret. There are some electoral advantages to members of Congress to doing that. So I think when you start thinking about that, it's going to be very, very interesting to see how it reacts to all of this.
And in fact, that's what Gorsuch argues all the time, right? I mean, Gorsuch argues for tightening the non-delegation doctrine, the major questions doctrine, that we need to put Congress to task, right?
Yeah, but then Gorsuch joins the majority opinion in Slaughter. I mean,
right. Exactly.
I mean, Gorsuch has a funny way of sort of talking out of both sides of his mouth when it comes to the relationship between Congress and the executive branch.
For sure. All right, so I have another question here I think we have time for. In light of the fact that Chevron deference no longer exists, should the courts have a different standard for determining if an executive order exceeds statutory or constitutional authority?
So I don't know about a different, I mean, just to put this in context, right? So Chevron deference was the idea from a 1984 Supreme Court decision, shockingly called Chevron, that when a statute was ambiguous, if the executive branch agency tasked with enforcing it adopted a reasonable interpretation, that interpretation would govern even if a court might have adopted a different one. Getting rid of that opens the door to more judicial review of executive orders and more de novo review. I guess, my view is I don't know that there should be a different standard. I think there should just be a standard. And, I think this Supreme Court has done a remarkably good job of not holding itself to standards, not articulating them and then not following the ones it hasn't articulated. And so, it would be easier to resist the charge that the court is acting differently based on who the president is if there were a more objective set of criteria that the court applied to executive orders for us to then assess, are these criteria being applied consistently?
I agree wholeheartedly. And I think on the birthright citizenship, I don't often agree with Justice Thomas. But I have for a long time when teaching, have said, look, I might not agree with him, but he's consistent. And when his opinion in the birthright citizenship cases, I was, this man spends many, many pages, interpreting a word that's not in the Constitution after years and years of berating his colleagues for using words not in the Constitution. So I do agree. I think that there's such inconsistency that opens the court up. All right, I think we have time for one more question. I'm sorry we won't get to all of these questions, but someone asked, it's a long way off, but what's going to happen in the law firm cases?
I mean, the Trump administration is going to lose the law firm cases, and it already has. I mean, the executive orders targeting, I guess it was 4 different sets of law firms and sets of law firms, are pretty blatant First Amendment violations. The district courts all concluded that they were, we talked before, Chad made the point about the administration being strategic about when and how it appeals. It's appealed those rulings, but only begrudgingly and only at the last minute, which says to me their heart's not in it. My bet is that the DC Circuit, the Federal Appeals Court in Washington, affirms those injunctions and there's no cert petition. And this doesn't even go to the Supreme Court. But I've been wrong before, but I feel like the government's own behavior is the tell here.
Yeah, I really was surprised the appeals even got filed. I sort of expected all that to quietly drift into the ether, but I think that's probably right.
All right, in the last 60 seconds, can the panel preview how the court will review the anticipated executive orders regarding midterm elections based on alleged election security? 60 seconds.
So, I mean, the lower courts have already blocked all of the relevant parts of the executive orders President Trump has already issued with regard to the elections. That pattern, I think, is likely to continue. I don't know how carefully folks are following the lawsuits where DOJ is suing states to try to obtain voter roll information. DOJ is 0 for 15 in those cases. Sounds like my high school baseball batting average. Right. So, for as much, I am very critical of the current Supreme Court. But I think that elections are a place where the court has maybe interfered more than it ought to have. But I actually think that the president's efforts to insert himself into the midterms have already not fared well legally and will continue to not fare legally.
I think the burning question here is, after you went 0 for 14, who's the coach who put you up there the 15th time?
Well, I was pitching and we played in a no DH league, so he sort of didn't have a choice.
All right. Well, thank you so much to both of you, to Chad and to Steve for joining us, and to all of you online today. We really enjoyed this. So yeah, thank you, everyone. Have a wonderful afternoon. Take care. Bye.
Thank you, guys.
Thank you so much.